school. I'm certainly not a professor, but we need to go through a few of the concepts here. And one of the most important concepts is the fundamental role, one of the fundamental roles while y'all are here. As the judge has told you, he's the judge of the law, but y'all are the judge of the facts. And what does judge of the facts mean? Well, a big part of that is that you determine credibility. You determine which witnesses you want to rely on or not rely on. You can rely on a part of a witness's testimony, all of a witness's testimony, one against many, many against one. It's up to each one of you individually to make that determinations and decisions, and then to collectively discuss those into a group decision. But credibility is important. Is it believable? Is what somebody's telling you believable? And there's many things you can consider in credibility, but a few of those are the demeanor of the witness on the witness stand, whether the witness has a reason to be biased, whether the testimony of the witness was contradicted on one hand or supported or corroborated on another, whether the witness has been dishonest in the past. And again, you can believe witnesses all against one against others, and you can believe portions of a witness's testimony as you see fit. Same thing goes for experts. Expert is a legal determination that allows them to give an opinion. Just because someone's qualified as an expert doesn't mean that you have to accept their opinion. You can judge that based on your assessment of the credibility and the relevance and the believability of that testimony. There's nothing different about that when someone's an expert. Beyond a reasonable doubt, I talked about this at the beginning of the case. And it's our burden. It's a burden we welcome. It's how this system works, that we have to prove the guilt beyond a reasonable doubt. And what is a reasonable doubt? A reasonable doubt is a doubt that makes a reasonable, honest, sincere juror hesitate to act. It's proof that a reasonable person would not hesitate to rely on in their affairs. But a reasonable doubt is not and leaves you firmly convinced of the guilt of the defendant, but it doesn't have to overcome every possible doubt. It doesn't have to overcome every possible doubt. I used to try a case against a defense attorney, and he would pull up a picture of something. Right here I have the Mona Lisa. And he would tear off a piece like that and say, ladies and gentlemen, that's reasonable doubt. And my response to that is, you still know what this is, right? You still know what it is. And that's reasonable doubt, okay? If you still know what it is and you're firmly convinced, then it's your duty under the oath that you've taken as the judge will give you the law to convict the defendant. Direct and circumstantial. Directly proves the existence of the fact, and circumstantial evidence is proof of a chain of facts and circumstances indicating the existence of that fact. And we talked a little bit about that at the beginning. Sometimes people in common discussions will say, oh, the case is just circumstantial. But the law says that doesn't matter. The circumstantial evidence can be just as good as direct evidence. It is just as good. It makes no distinction between that, and the judge will charge you on that. There's no greater degree of certainty required of circumstantial evidence than of direct evidence. The circumstances must be consistent with each other, and when taken together, point conclusively to the guilt of the defendant. And I gave you all an illustration at the beginning. I'm not going to redo the whole thing, but about being inside. And you go outside and it starts raining, then you know it's raining, okay, because you got direct evidence, you're getting wet. But if you go inside and you're in a closed room and all of a sudden it gets dark and you hear thunder and you hear the wind rustling and you hear the rain coming down on top of the roof, and then after an hour or so you go outside and the sun's shining, but there's limbs all down in the yard and it's wet as far as the eye can see, and there are puddles in the yard and puddles in the driveway. Is there any reasonable doubt what happened, that it rained? Now, again, I'll say it again. Supposedly, I guess somebody could have sprayed the whole neighborhood with a hose and blown a fan to blow the wind down, or blow the limbs down, simulate wind, but that's not a reasonable doubt, ladies ladies and gentlemen. Circumstantial evidence can be just as strong as direct evidence. It is just as strong. The law makes no distinction just because it's circumstantial. All right, let's talk about murder. Murder is the willful killing of someone with malice aforethought. It's the unlawful and willful killing of any person by one with malice aforethought. The crime of murder is really, as far as the elements go, fairly simple. The operative terms here, the most important terms, are malice, which is the mental state that the person must have, and aforethought. But let's talk about those. What exactly do they mean? Malice, and it can be any of these. It can be the hatred, ill will, or hostility towards another, but it also can be the intentional doing of a wrongful act with an intent to inflict an injury under the circumstances that the law would infer an evil intent. It can be a general malignant recklessness of the lives and safety of others. It can be a wicked or depraved spirit intent on doing wrong. It could be using firearms, shotgun in a blackout to blow somebody away. That can be malice, ladies and gentlemen, if that's what you decide. Aforethought. Sounds like it has to be planned, and certainly planning would account for a forethought, but it may be conceived at the very moment, a split second, or in conjunction with the act. So a forethought doesn't require planning for that malice to occur. All it has to do is exist in the moment, just a split second or in the moment that the act occurs. So when that trigger's pulled, as long as there's that intentional doing of a wrongful act, intent to inflict an injury, that would be an evil intent, a malignant recklessness, which you can infer from the circumstances of the case, then that's all you need. And how do you do that? I said infer, because people don't always yell out what their intentions are. You have to infer it from the circumstances of the case itself. Look at the crime scene, look at what happened, look at the backstory, look at all the circumstances that come together, and you can infer malice from those. Last little bit of law school. Malice and drugs. Voluntary intoxication does not impair a person's ability to act with malice aforethought. That's a legal principle. If you voluntarily get intoxicated, it is not a defense to a crime, and it does not negate the malicious nature of that crime. If one voluntarily intoxicates themselves, they are just as responsible for their actions as when they are not intoxicated. And the judge, again, take what the law comes from the judge, but this is a legal principle that you will hear. Voluntary intoxication is not a defense to a crime. And why does the law say that? Well, you can't take whatever it is and deny responsibility for what you've done under the law. All right?